Good morning, everyone who's watching this from India. Good afternoon, good evening to all others watching from different parts of the world. My name is Ashish Bhardwaj. I'm from the Jindal School of Banking and Finance at OP Jindal Global University. Welcome to the first session of day 3 of this Law Summit. And this session is on the economy of law and economics revolution. We are going to be talking to 4 distinguished law professors who are part of this panel who are going to reflect on this topic. I'll very quickly introduce them. Professor Robert Ahdieh, he's Dean and Anthony Buzbee Endowed Dean's Chair, School of Law, Texas A&M University in the United States. Professor Robert Cunningham, Dean and Head Curtin Law School in Australia. Professor Kevin Johnson, Dean of School of Law, University of California, Davis in the US, and Professor Shilpi Bhattacharya, my colleague, law professor at Jindal Global Law School. If we were just talking about law and economics before we started, if my 4 panelists would have been 4 economists, then we would have probably had 5 different views on this subject, on this topic. And if one of them went to Chicago, then we probably would have had 6 to 7 different opinions. That's how a joke on economics goes. But let's see if we can prove it wrong towards the end of this session. For the audience watching us on YouTube and elsewhere, we are going to be talking for about 60 minutes. I'll very briefly introduce the theme, the topic, and then we'll have a moderated discussion in a Q&A format where I've requested all panelists to restrict their responses to about 3 to 4 minutes per question. This will be followed by a brief Q&A session with you, the live audience. I'll be receiving the questions and comments you'll be making on different platforms and portals. And for the panelists, if you have a counterpoint to make to one of your fellow panelists, then please feel free to interrupt me and we'll give some time. All right, so maybe around 120, 110 years ago, Oliver Holmes very rightly said that for the rational study of the law, the black letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. More recently, in India, Justice A.K. Sikri from the Supreme Court of India said that law has implications across disciplines, not just law, and it really impacts jobs, economic growth, government revenues, issues of taxation. And sometimes he goes on to say that macroeconomic fundamentals are predominant, which is why Indian courts, according to Justice Sikri, are becoming increasingly receptive to economic analysis of law. Now, it wasn't like this for a very long time. The last half a century indeed witnessed an emergence of this field, this very interdisciplinary field called law and economics, which can be considered as one of the most important intellectual developments by many legal scholars and economists around the world. Not only does this discipline direct obvious economic areas such as antitrust or competition law, intellectual property rights, regulation, industrial organization, but it has implications on all other areas of law, most other areas of law. Again, it wasn't like this. About 50, 60 years ago, this discipline, or rather movement, was largely coterminous with the application of economics to antitrust, to what a firm or an industry wishes to do or does. But over time, the impress of economics has become stronger on the calculation of damages in torts, on contracts, on securities, even issues of family law, monetary relief in divorce cases, and there's so much more. There has been a growing interest among the economists as well as lawyers and legal scholars in using economic theories and empirical methods to enhance our understanding of the legal systems. The discipline of law and economics has had a huge influence on how several countries have dealt with important issues ranging from environment, property, land, mergers, banking, and so on. But it has also shaped, very importantly, public policy responses to social issues like child labor, public safety, crime control, and many others. How law and economics gained prominence in becoming such a vital guiding principle in the rule of law is described by many as a revolution. Now, whether laws shape preferences and in which direction is important for those conducting cost-benefit analysis of judicial decisions. and for those who want to know whether the decisions accord with the democratic will of the public, of the people, especially if judicial decisions shape that democratic will. Now, this is where an eminent economist, an Indian economist, Kaushik Basu, who's at Cornell now, he points out the shortcomings of the discipline of contemporary law in economics, the way the discipline has shaped and has become visible now. This is more so in certain developing countries, including India, where there's a constant refrain in how the law is fine on paper, but the implementation faces some challenges. Another major criticism is around the rather convincing criticism around the notion of rationality, which is really the bedrock of this entire economic foundations of law and economics. Thus, more recent and advanced developments in the field of law and economics are now trying to answer complicated questions like why do people follow some laws but not the others? Why do some societies seem law abiding and others do not? It is also closely linked with a very interesting book that came out a few years ago titled Why Nations Fail by an economist, Darren Acemoglu, which also tries to understand some of these challenging questions from a slightly different lens. Another one is, why is corruption more widespread in developing countries or in certain developed countries and not others? Governance is another issue. So it is a very vibrant area, and I'm very happy that I'm joined by four people who can really do justice to this topic. Let me dive into the first question, a fundamental foundational question that I have in mind for each of my panelists. And the question is, what is really the contribution of economics in developing legal systems? So your personal view on this question. Let me start with Shilpi, who can bring perhaps some perspectives from the Indian legal system, and then we'll move to Australia and finally to the US before it's too late in Texas. Over to you, Shilpi. What is the contribution of economics in developing the legal system?
Thank you so much, Ashish. I mean, I think that is such an important question that I don't know if I can do justice to it in 4 minutes, but I think economics, both positive and normatively, has played a very important role in helping us to understand sort of how the legal system works, both in terms of the design of legal rules, as well as you mentioned, in terms of sort of how well legal rules are working, as well as sort of the entire institutional structure of the law. So if you think of economics as a discipline, so it is in itself such a vast discipline. So if you think of sort of empirical economic studies of sort of how of court systems like the Indian Supreme Court, there have been studies of the functioning of the Indian Supreme Court, pendency of cases. So in that sense, empirical economics has proved to be one of the more effective disciplines to help us sort of understand where we're going right or wrong in terms of how the legal system is working. And then in the Indian context, at least from an academic perspective, we've seen less of sort of academic contributions in terms of understanding the implications of sort of the application of economic theory to legal rules. So here, I think we have a lot to learn from sort of the academic contributions of scholars in other countries. So for instance, in more developed areas like competition law in India, we are seeing that there is sort of more of an economic analysis happening. But it's still in other fields of the law, like tort law, contract law, where it's more developed in other countries, we don't see that kind of an economic analysis playing out. And of course, we also see that some of the cases of the Supreme Court, some of the older common law cases, for example, contract law cases, we see the courts mentioning concepts like risk allocation. So there's definitely sort of an application of some of these interesting economic principles, but it hasn't become very mainstream, I would say, in within the Indian legal fraternity, and also within sort of more specialized regulatory tribunals, as well as more specialized regulators like the Competition Commission of India. while they do have economic expertise, we still see that they're not as as I don't want to use the word comfortable, but they're not as they're not using economic analysis as much as we see in sort of in more advanced or more developed countries. But I think in terms of the contribution that economics has made and can make to the law, I think first of all, because economics is considered quote unquote to be a science, so I think it does bring a degree of objectivity to the way that we understand the law that I think is so different from the way that we would otherwise analyze the law if you were looking at it through the prism of other disciplines. So I think the degree of the objectivity that economics as one disciplinary prism for understanding the law provides is really significant. But also I think what makes economics significant is just in how it how it can provide this unique frame to understanding legal problems and legal context. So for instance, if we're looking at the design of legal rules and we think of sort of the error cost frameworks, which is like one sort of tool that we might use if we're using sort of a law and economics approach, then sort of, what is the cost of getting this legal rule wrong, or what is the cost of taking a wrong decision, and what is the benefit of taking a wrong decision. So that error cost framework is a very interesting sort of way of analyzing judgments, analyzing rules, and that's just one example of how we could how economics provides a very unique sort of perspective for us to understand and even sort of analyze the law. And of course, for people who are not familiar with economics, and this is why it kind of becomes harder to integrate it into mainstream sort of legal analysis, because it seems very sort of alien to have these kind of objectively measurable sort of answers to legal questions. But like I mentioned earlier, I think that is also the attraction of economics, that there is sort of a very intuitive, sort of clear, sort of predictive framework that that economics provides in terms of how we could think about sort of how we could predict what legal actors would do, and how we could sort of think about outcomes of legal rules. For example, that a particular remedy for breaching a contract would may or may not sort of provide an adequate solution in terms of what is the problem that we're trying to solve. So is, say, specific performance better, or are damages better in a particular context? And economics provides a very clear solution to that problem. Yes, I'm sorry, I'm going on.
No, that was, thank you so much. We are on a great start with this. Thanks for your answer. Let me move to Robert now with the same question, Robert. What, in your view, has been the contribution of economics in developing legal systems?
Thanks for the question, Ashish, and thanks to the Jindal Global Law School for hosting this wonderful event. I guess at the heart of the question is another question, which is, what is economics? And there's many ways in which we could come at that question, and my answer is probably a little bit too simplistic, but the way in which I often conceptualize economics is that it's about who gets what. And if we think about economics through that prism of who gets what, then it obviously has a pretty significant impact upon the rule of law in a practical sense. So Ashish, it goes back to the dichotomy that you drew out in your introductory comments about the theory of law on the one hand and the practice of law on the other. I don't think Australia is alone in its common law system, in the sense that many cases that make it to court are backed by significant wealth. So that is, the wealth itself ends up having a very large impact upon how the common law develops over time. And we could unpack that particular issue through a number of different lenses. We could talk about the role of corporate power and the accountability that issues that relate to that. I know that it's possible that we'll talk about welfare economics along the way, but another area of interest, I think, in this domain is what's sometimes referred to as public choice theory, which really talks, in my view, about the role of concentrated interests in shaping regulatory frameworks. And I mean, particularly in Australia, but again, in many other countries, we see that the regulatory frameworks that have been established by the legal system in Australia are very much shaped by big mining houses and those that have an interest in essentially exploiting natural resources for private gain. But when we think about it in those terms, there's always this tension between private and public. And I guess from a normative point of view, what I think needs to happen is we need to start thinking about the way in which we have constitutionalized power in the past. So we could think about Montesquieu and the way in which Montesquieu, in the spirit of laws, talked about the need to separate power. But we all know why that is, because power needs checks and balances. But have we adopted that type of thinking into the economic frame? Have we thought not so much about separating political power as we do with the executive, the legislative, and the judicial, but how to separate economic power? And in some ways, that's what competition law is about. That's what even intellectual property, to some extent, seeking to balance out private and public interests, is ultimately about mediating between private and public. But I don't think we've really thought about it through a constitutional lens. And so in some of the work that I've been attracted to, we could speak perhaps of the separation of economic power doctrine and think about the various aspects of law that go to separating power in the economic domain. Why would we want to do that? Well, the simple answer is the rule of law, and particularly focusing on the practical dimensions of the law. If we don't separate economic power, we know what happens. The economic power becomes concentrated. And when it becomes concentrated, it then has significant impacts upon regulatory frameworks, which then impacts upon the way in which the law is created and the way in which the law is developed. So I might speak to some of those themes later if I have time, but thanks for the introductory opportunity.
Thank you, Robert. I really like that you took all of us back to another fundamental question of what is really economics before understanding more about law and economics. And you said it's who gets what. So I think it's also important to add one layer to it. In understanding who gets what, we need to understand how much and when. So the issues of equity, efficiency, all of this will kick in. But thank you so much for those introductory thoughts. Let me move to Kevin now with the same question. Kevin.
Sorry about that. Thanks very much. And I very much appreciate this opportunity to talk with you all a little bit about law and economics. I come at the issue from a particular perspective, I guess. It's funny, in some ways, I studied economics as an undergraduate, and then I went to law school, and I thought the study of law was much like the study of economics. Same kind of classes in some ways, same kind of exams in some ways, although I did better in law school than in economics. And it strikes me that Robert's exactly right. Economics is about who gets what, and law is about who gets what. And so they work well together. And I think it's unquestionably the case that law and economics has really transformed the way that most judges, scholars, and lawyers think about the law in the United States, and it's had an impact on legal rules. And I think it's helped improve the focus of legal rules and legal decision-making. And in the end, I'd conclude that economics unquestionably can aid in the analysis of legal issues and rules. At the same time, I think it's a big mistake to think that economics is black and white, cut and dried, and completely objective, and a easy way to reform the law. We all know that legal rules aren't clear-cut, And the same is true for economic analysis. As Ashish said in the introduction, you get 5 economists in a room, you may get 6 opinions about what the rules should be. I think that economic analysis has many variables. They have to be estimated. Outcomes do not always come out the way economists say they'd come out. Numerical values have to be assigned to certain injuries if you apply it to law, and those can be debated. I mean, in the United States, there's a famous case involving the Ford Pinto, in which there was a cost-benefit analysis engaged in by the Ford Motor Company. They decided not to repair a defect in a car because it would cost more to repair it than it would to pay off judgments in wrongful death actions. Raises all kinds of questions, including, well, is economic analysis appropriate when you're dealing with people dying? How do we value the loss of life? And what about pain and suffering, which is very different to objectify? So I think it's a mistake to think that economics can dictate answers and can help us finalize legal rules and the outcomes of cases. Like law, there's room for discretion, there's room for judgment. When law and economics tools of analysis are employed, you'll have economic indeterminacy, and that necessarily means legal indeterminacy. So in the end, I don't think that law and economics is a silver bullet for clear legal rules. In addition, law and economics has a decidedly political point of view. Many adherents, particularly in the United States, but not all of them, are conservative. Law and economics has been questioned as overly conservative and too conservative an influence on the law. So in the end, I think that law and economics is a useful tool, but it is exactly that. And it's like other tools that are available to judges, lawyers, and scholars in looking at the law. You can learn from many different disciplines about how to fashion legal rules. You can look at the social sciences, like the US Supreme Court did in Brown versus Board of Education, in holding that segregation led to poor educational outcomes for African-American students. But I think history, sociology can also offer some insights into legal rules. And in a very different political sort of position, some would say that critical race theory, which analyzes the law by focusing on the law's treatment of minorities in a society, is a useful tool for looking at the law. It's added important insights and context to legal analysis. So I think that while economics can be a useful tool, lessons and tools from other disciplines can also help as well.
Thank you very much, Kevin. Economics is a tool within a portfolio of tools available to the legal system as such. Thank you for sharing those thoughts. I'm going to take the same question to Bobby, our 4th panelist. What are your thoughts on this, Bobby?
Well, thank you for Ashish having me here, and thank you to Jindal for this wonderful gathering. This panel, but really this entire gathering, like so much that Jindal does, really is world class and truly global in every sense of the word. And so, thank you for the opportunity to be here. I will try not to reiterate things that we heard from my fellow panelists. They have covered lots of the relevant territory. Let me say a little bit about, the basic question you started with was the contribution of economics to developing the legal system. I'm going to say a little bit about that, and then I'll come back to what lots of the discussion is focused on, which is the law and economics as a methodology for analyzing law. In terms of the broader kind of what is the role of economics as to the legal system. So a few sort of broad thoughts. The really 2 things I'll highlight. The first is that we do have seen over time, and I can say this without any prejudice to the baseline systems of custom, but that as economic growth and wealth increases in jurisdictions, there generally is this movement away from relational contracting, from custom as a mechanism for relationship building to institutions and structures, right? So again, rather than relying on tribal relationships, on custom, on tradition, and on this kind of relational dynamic, there is the opportunity to put in place institutions, and there is a drive, a push to put in place institutions that allows for further economic growth, further economic activity, and the like. That's an important phenomenon, or it can be an important phenomenon. It's not an unmitigated good. It can be destructive in many ways as well. But broadly, it can be understood as an important component of the interrelationship between economics and economic growth, and what the legal system looks like, and the role and the scope that the legal system plays. I'm going to give then my second point, kind of to connect it to a concrete setting for that I think highlights that interrelationship that can emerge. I spent a good chunk of the early 1990s living in what was initially the Soviet Union and then became independent Russia. And I was very involved in legal reform issues at the time as the Soviet Union was collapsing and independent Russia and the other republics, now countries, were emerging. Among the folks who were working very actively and prominently on economic reform at the time was a guy by the name of Jeffrey Sachs. Jeff Sachs really in many ways spearheaded the kind of shock therapy, or was the theorist behind the shock therapy model of privatization that was put in place in Russia and a number of the other post-Soviet countries and republics. And again, it was a small community of Americans and really expats in general in Moscow at the time. And so I came to know Professor Sachs at that time. And at occasion, it was a small group, maybe it was 30 or 40 people. And Jeff was giving some remarks on what needed to happen in terms of economic reform and economic vitalization in then independent Russia. And after he finished and it came time for Q&A, I was at the time just an undergraduate student, but one who was focused on law and legal reform. And I knew him well, and I thought I would give him a softball question. So I stood up and I said, what is the role of law in what you're describing? And his response was, we'll get to that later. And I said, you mean my question? He goes, no, law. And I said, what do you mean? And he went on to explain, and he said, right now the task is to unleash the forces of economic growth and capitalism and so on and so forth. And the law would follow naturally from that. Needless to say, unless you have been completely oblivious to the ensuing history of Russia, Jeff was wrong. Now, the end of the story that I'll mention is that some years later, he gave a lecture at Yale Law School, from which I graduated, that was all about the importance of law in economic growth and development. And they sent a copy of this lecture to all Yale Law graduates. And so I got my copy and I scribbled a note in the front and I said, Jeff, I'm glad to see you finally figured out the answer to my question. And I sent to him, and he hasn't talked to me since then. But it highlights the ways in which there was, and I think there is in some corners of economics still, this notion that law is a simple outgrowth of a certain state of the economy, as opposed to critical ingredient and almost dispositive factor in determining the path of economic growth and our lives. The obvious ones we talk about are property rights and contractual rights. So the notion is you can privatize, but unless there are clear lines of who owns what, property law and contractual laws that allow you to engage in contracting, it is hard to navigate that economic liberalization effectively. But others follow very readily. What about the lack of a judicial process, which requires rules of civil procedure? What about a bankruptcy code that allows entities that have gone bankrupt to not be subject to imprisonment or to execution or the like, but instead are subject to some mechanism of bankruptcy and reform? All right, so those are some thoughts on the relation between economics and the legal system generally. Very quickly, because again, I think we've covered lots of this. Law as economics as a tool vis-a-vis law. The first thing I would say is I totally agree with Kevin that it is a problem that not uncommonly in the law and economics community in the US, and I think increasingly overseas as well, economics is thought of as the tool. I used to be, and I use law and economics in my work, and I was used to defend it to a colleague of mine who was very critical of law and economics by saying, look, it's just one tool like others. Nobody is claiming that it's the only tool. And we had a presenter came, I won't say the name, but a very prominent law and economics scholar, but also a very mild, unassuming guy who I thought would be reasonable. And he presented a paper called The Nobel Prize in Law. So anyway, we went to his talk to hear his presentation, and his entire presentation consisted of saying that we don't need a Nobel Prize in law because we already have it. It's the Nobel Prize in economics. In essence, arguing that the only real way to analyze law was through the economic lens. That is to my mind, a very foolish device. That said, I would also push back a little bit. I think that economic analysis used properly as a tool, along with the other tools that Kevin also mentioned, can have a kind of a discipline, or can encourage a disciplining effect, right? It can force us to ask questions that we might not naturally otherwise ask. Now, to be fair, critical race theory, as Kevin mentioned, and law and sociology and law and psychology and law and politics can do that also. But I do think that the economic framework is one that sometimes can push us more than some of those, because it's relatively new or unfamiliar or the like. But we have to guard against this hegemonic notion that economics is really the only way, or even the primary way, to understand law, because that then produces the range of political fallacies and biases that Kevin also described.
Thank you, Bobby. Thanks very much. Well, I was hoping that one of the panelists would also talk about what the law has to teach economists, or to the discipline of economics, but I guess we'll tease that out as we move on with the discussion. I want to bring us to the next question, highlighting the role of judiciary. We know that how laws are interpreted and enforced ultimately depends on what behavior is in the rational interest of legislators, judges, lawmakers, people in general. And there is an inherent problem with this, as we all know. Now, the question is around the role of judiciary in promoting the intersection of welfare economics and law. It came up in the introductory remarks that some of you made. Should the concept of welfarism be the sole evaluation criteria for legal rules and institutions? And how can it benefit the society? Can I start with you, Shilpi?
Sorry, yes, absolutely. Thank you so much, Ashish, for that wonderful question. And also, just very briefly to the previous question that you asked, I think the reason why most of us didn't mention how law influences economics is because in so much of sort of the law and economics movement is about what law can learn from economics. And this is sort of one of the criticisms of the movement, that it's all about sort of economics kind of dominating our analysis of the law, rather than sort of, or even economists dominating sort of, because I did a PhD in law and economics, and there was a lot of friction between the 7 lawyers and the 7 economists who were in the program, and it was always the economists telling us that we didn't know what we were talking about. So that's basically what law and economics is about: economists telling us how we should interpret the law. But just quickly on to the question that you asked. So when we think of sort of the concept of welfare, what we think is, of course, that sort of getting what we want. So getting most of what we want. So we know what we want, and then sort of we act in a way that we get what we want, whether those are, and that's the maximization of utility. And in a lot of sort of the normative frameworks of a lot of sort of laws are designed to sort of create systems through which you can maximize your utility. But that, of course, presumes that we know what we want. And this is where also there is sort of some literature that, we don't always know what we want. And also, how do you actually come up with knowing what and aggregating everyone's utility, right? So how do you sort of create laws that, then you basically become, because everyone has different preferences. So if you're trying to sort of create a world where you're making everyone happy, you're basically doing it at a very, very basic level. So you're oversimplifying it to such a degree that sort of, is there any sort of benefit to using that tool when it becomes so oversimplified to that extent? And then the questions of sort of the diversity of population, of inequalities, of sort of where different people are coming from, and then do those rules really serve different people? Then that's a question that sort of comes up. So when we think of sort of the role of judiciary in this regard, I think one thought that I want to put out there is that so the judiciary is supposed to promote justice, right? So and justice is, in a sense, an outcome that we all think should be the right outcome, and that in itself gives us some utility, right? So when justice is done, that in itself might be a welfare enhancing outcome, and who's to say that that's not a better outcome than some sort of mathematical sort of determination that we've made based on sort of aggregating the preferences of different people. So so in terms of sort of what judges do, and sort of this is also bringing in concepts like fairness, like equality into economics. So if you want to bring those, who's to say that those are not important principles that people want to live and want to have in their lives, and that doesn't give them happiness? So if judges are sort of bringing those kind of principles, then why not? So that's sort of just what I want to say, that sort of maybe we need to go beyond welfareism in the truly economic sense and think of sort of other concepts as well.
Thank you, Shilpi. Robert, would you agree? Do we need to go beyond welfareism as an evaluation criteria for legal rules and institutions?
I mean, short answer is yes. But how do we do that, I guess, is the follow-on question. Again, there's a number of different ways of coming at welfare economics, but I tend to look at it through a cost-benefit lens. I mean, that's part of what welfare economics is. It's certainly not the whole story. But it, to some extent, goes back to Kevin's point about the Ford Pinto example and the cost of a life, for instance, and weighing that up against the various benefits. That also flows into corporate accountability questions, which I touched upon earlier. I guess one of the things that I would state from the outset is that the judicial system and the political economic system generally is not always particularly good at measuring costs. It seems to be better at measuring benefits, and this is particularly the economic system, I would say, is better at measuring benefits rather than costs. And that's often because of the private-public dichotomy. That is, the benefits usually are privatized and the costs are usually socialized. And so you end up with that sort of public choice theory dynamic where you have a fractionalized interest when it comes to dealing with the costs associated with economic activity. But I think the law does have a really important role to play in accounting for costs, and whether or not that's done through an economic lens or not is perhaps not the point. This might seem like a bit of an abstract example, but the foundation of the Australian legal system over 2 centuries was really built upon a false fiction of terra nullius, which was to say that no one lived on this continent prior to 1788. And then we sought to build a legal economic system with the political economic dimensions that flow based on that falsehood. But yet, after a couple of centuries, the High Court of Australia turned its mind directly to that question and actually confronted it and said, well, actually, that's not true. And in doing so, it was really, from a very macro point of view, able to acknowledge the costs associated with the colonial foundations of this particular country. And again, while that might seem like an abstract example, I think there are many other micro examples scattered throughout our political and social and economic system where costs and benefits are askew. I'm particularly interested in intellectual property, and perhaps we'll get to some of those issues later, but just following on briefly, that the intersection between law and economics is obviously the heart of what we're talking about, but a part of that equation also, I think, particularly for the future, is the intersection between law and technology. Because more often than not now, it's technology that is determining what we can and can't do rather than the law itself. And I mean, people like Lawrence Lessig in the US have made that point very clearly through the sort of code analysis to say that, you know, computer scientists are perhaps the new lawyers in a sense, in that they are able to determine who does what. So I would like to, I think, flesh out some of those law and technology dimensions and how those law and technology dimensions relate to this law and economics discussion. Thanks, Ashish.
Thank you, Robert. I'll take the same question to Kevin now. Kevin, your views on the role of judiciary in promoting welfareism or welfare economics?
Well, I think courts have done their best to try to integrate economics into their analysis. But we have to remember that judges, at least in the United States, for the most part, aren't economists and are going to only be able to really apply sort of the signposts of economic analysis as opposed to the nitty-gritty of economic analysis. I think the benefits of economic analysis to judges has been in thinking about things like costs and benefits, like externalities, the impacts are probably the greatest in antitrust law, but still, as Bobby mentioned, economics creates some things that we should focus on, and judges do focus on more now than they did in the past. In their analysis of legal issues. At the same time, I think that economics was in the deep background of many legal regimes well before the development of law economics and played some role historically in the development of legal doctrine and analysis. I'll give you an example from the United States. The rules that govern the federal litigation process, the federal rules of civil procedure, which were put in place in 1938, they focus again and again and again on economy and efficiency in civil litigation. They create rules that foster and promote these values, maybe too loosely related to economics, but still loosely related to economics. They require things like joinder of claims in one lawsuit as opposed to many lawsuits, joinder of parties in one lawsuit as opposed to many lawsuits, huge class actions to resolve as many disputes out of one wrong as possible. I think these are the kinds of economic concerns that you expect judges to handle rather easily, even though it's elementary, I give you that. But I think trying to get judges to really focus deeply on economic analysis in welfare economics, it is going to be difficult. Even law professors with PhDs in economics have to grapple with these things. I think it's an awful lot to expect judges to be able to, as amateurs. And that's not, I don't mean that to be an insulting term, but that's what they are when it comes to economics.
Thank you, Kevin. Bobby, your thoughts? Is it simply a problem of relying on signpost economics, or is the problem deeper, where perhaps rational interests are being pursued by judges who might simply be irrational? What's your take?
I suspect it's a little bit of both. So let me actually begin with since we're talking about judiciary in particular, and sort of law and economics, the kind of historical point of reference, and really contemporary too, that I thought might be interesting for folks is, so much of the influence in law and economics has actually not come exclusively via academics, but has come via, in fact, the judiciary and public officials more generally, but particularly the judiciary. And that's a product of a very systematic program that was undertaken starting a little bit in the 1970s, but even more so picked up in the 1980s, funded by a group of organizations, the Olin Foundation and others, to develop these judicial training programs in law and economics. And they were very pleasant, always in very pleasant locations, that judges would be brought to be trained in law and economics. And again, one can construct the nefarious version of that. And I don't think one would be wrong to do that. But even without the nefarious version of it, this became I'm going to say an ideological approach to the use of economic analysis by the judiciary. Why ideological? Because it came from a particular frame of neoclassical economics that was being pressed and advanced. That neoclassical model in terms of its assumptions of that the baseline is efficient, notions of the common law was the efficient model because it's a product of market-like forces, as opposed to statutory and regulatory action is in essence, by definition, inefficient because it involves market interventions, which are not subject to the same kinds of pressures. It pressed for devolution of authority from federal to state to local level, because that would invite sort of competition among jurisdictions, jurisdictional competition, regulatory competition of various sorts. So it was a particular frame of reference that was ideologically pressed forward. So it is the case, again, as Kevin touched on earlier, that today law and economics, as it plays itself out in the judiciary, has tended to be grounded in that particular model of economic analysis. Now, the good news is that the legal literature has moved a long way from that. So it's probably the case that if we did a search for law and economics analysis, a huge chunk of articles in the last year or two in the United States on law and economics will be grounded in behavioral economics, alternative game theoretic models than what have been used traditionally. Some of my own work has been on a shift in analysis from prisoner's dilemma games to coordination games and what that means for the scope and appropriate role of government institutions and regulation. So I think that in the scholarly literature, there has been more and more recognition and embrace of that. How much that is transferred or translated into the judicial branch, I think some, but not nearly as much as one might hope. It's also the case that, an article was written by a former colleague of mine now some 10, 15 years ago, in which she said, when everyone does law and economics, no one is doing law and economics. Now, what did she mean by that? She was saying that she actually did a search for the references to efficiency in law review articles. And she found that it had spread so widely that in essence, if you use that as the measure of what law and economic analysis is, focusing on or attending to efficiency, that would of course capture 60%, 70% of the legal literature. And so she raised the question, if everyone is doing that, then can we say that anyone is doing that? Or has it become so diffuse and meaningless that it doesn't have any force anymore? The last point I would say on this is that part of this is also a disciplinary phenomenon. It's that it is hard to translate cutting edge economics into legal scholarship, let alone cutting edge economic analysis into legal scholarship, and from there to judicial analysis. Now, there's nothing unique about economics. Now, I could do the same thing with cutting edge psychology or political science or sociology. So what tends to happen is by the time you get to the bench, let alone to academia, but by the time you get to the bench, there is this incredible lag. So judges apply law and economics, but they apply the law and economics that economists were doing not even 20 years ago, 30 years ago and 35 years ago. So it's awesome that we have this pipeline, this kind of interdisciplinary pipeline, but the danger is the pipeline is slow and it twists and turns and it gets narrower and narrower. So even the judge who says, I'm doing smart law and economics is doing the smart law and economics of the mid 1990s. And economists wouldn't even recognize what they're doing anymore.
Well, thank you very much, Bobby. We have questions coming in from the audience, and I'm going to actually pick one that aligns very well with what you said, Bobby. And it's an open question to all the panelists. I'm going to ask Bobby first and then move on to the other panelists. So given that there are certain challenges with how economics can be, as a discipline, taken to law students in law schools, the question is, how do we bring in this intricate study of economic analysis into legal education to law students? Does it require a change in the structure? Does it require a change in pedagogy? Does it require anything that is currently very difficult for law schools to adopt? And I'll add another layer. Is all of this more difficult to do post-pandemic?
Good. All right, well, I want to hear what others say, because that's a great question. So I'm more interested in what others have to say. So I'll just very quickly say on the first part, lawyers are a conservative bunch. I mean, not in the political sense, but in the caution sense. And if you think about even for India and the United States and other common law jurisdictions, even more so, right? We have an entire legal system that is premised on the law is the law because someone 100 or 200 years ago said it was the law. And we've evolved a little bit, but very incrementally and gradually. So that translates into the law school curriculum as well. In particular, it shows up as, sure, law schools teach law and economics, and law schools teach law and psychology, and law schools teach law and social science, but they tend to teach it in isolated pockets, right? It is a separate course, or there's a particular professor who has a PhD in X, and so they weave it into their course. From my vantage, what I tell people is that I spent a lot of time as a dean out there among employers. I haven't found the employer who is looking for students who know less. They're generally looking for them to know more, and they actually don't mean more law. What they generally say is we can teach them the law, right? What they want them to have is a sophisticated understanding of the broader context in which whatever area of practice they're working in operates, whether that is psychology or economics or finance or political science or whatever else it might be. So I think, again, as law schools, if we can find ways to, in a more serious way, integrate the law and into things into as early a stage as our first, you're not going to throw contracts away and replace it with a law and psychology class or a law and economics class, but to weave those things in, it will begin to lay the foundation so that the students themselves go off and take bankruptcy, right? They're asking a different set of questions than they would ask otherwise. So that's the one. Post-pandemic, obviously, the biggest, from my vantage, impact of post-pandemic is physically during the pandemic, we all hunkered down, right? We hid in our bedroom with all the curtains closed and the doors closed. I worry a little bit that there are two paths that diverge in a wood post-pandemic. The other is a flourishing of innovation and creativity and new ideas. The people are excited about, we are back, we have opportunities to try new things, experiment with new things. And the other is that people have been becoming accustomed to the precautionary principle, and they're resistant to trying anything new. And if we see that, frankly, I think that legal education globally will suffer because to keep up with the world, we've got to be able to innovate.
Thank you. Thanks, Bobby. Shilpi, what do you think? You've done a PhD in law and economics. You teach in a law school. You routinely teach economics students. I know that. How can we get this right in our universities?
I think, no one has mentioned Posner yet, so I think I'll mention Posner. Posner said that sort of what's important is to convey the intuitions. So I think sort of in terms of how we it is important for law students to understand the intuitions of economics so that they can just apply the basic and have a basic understanding of what economic behavior sort of looks like. So I think in terms of how we communicate, and this also goes back to what Bobby was saying, right? So they don't have to know everything, but just in terms of understanding the intuitions, I think if we can communicate that to them, and that too, as Bobby said, across different across different classes rather than just through specialized courses, I think that would be a better way and a more effective way. So just in terms of just the basic understanding of what economics provides, I think is because if you go too much into the technicalities, I think we lose our students. So I think we should keep it simple, but it's important to convey to them at least open their minds to these different disciplines so that they know what the possibilities are, and they can go and and then you can have more advanced courses as electives where they can but at least the basics, all students should be communicated at least the basics. That's my thought. Thank you,
Shilpi. Robert, what do you think? Is the problem so grave that we need to change the structure and the pedagogy in law schools?
Law's a social science, right? In the same way that economics is a social science. So I think what's happened over time is we've tended to bunker down into our disciplinary camps and in a way separate things that in previous times were not separated. If you go back and actually read The Wealth of Nations by Adam Smith, it's not necessarily an economic doctrine that he's presenting. He was a moral philosopher or an ethicist, and there's a whole range of ideas in there that are applicable to the study of law, but yet we don't necessarily integrate original text from The Wealth of Nations into legal studies. There are a whole range of different ideas that can come from law and economics, whether it be through Adam Smith's original work in The Wealth of Nations, whether it be looking at Demset's ideas about the cost and benefit of actually establishing markets in relation to particular activities, whether we're looking at Ronald Coase and the nature of the firm and distinguishing between market activity, state activity, the firm activity, and perhaps social production as well. We haven't talked about social production, but Johan Benkler talks really nicely about that, I think, in The Wealth of Networks, and the role of the fact that economics doesn't answer everything, right? Because if you look at the development of things like music, language, science, none of those things were developed because people were getting paid to get out of bed in the morning. I mean, language is a very classic example of that, right? It just happens because society produces stuff. Some of that stuff is recognized in the economic system. Other things just happen naturally because humans are, social beings, and we can talk about behavioral economics and everything else. So from my point of view, I think it's really about breaking down these false boundaries between disciplines and recognizing that at the heart, law is a social science, with all that comes with that. The grey areas embedded within historical analysis, within economic frames, and the like. So that's what I would say.
Thank you, Robert. Kevin, your response to this question.
No, I think that it's a hard one, because when you talk about changing the curriculum, that's always a challenge, and something that, if I want to sort of take all my faculty's time for a year, I raise the topic of curriculum reform and give a committee the task of coming up with curriculum reform. They don't have to talk to any faculty members for the whole year because they're all wound up with curriculum reform. Seriously, I think if we want to, and I think it is important for students to learn tools of economic analysis and law and economics. I think we have to think more carefully about how we hire and how people integrate issues of economic analysis into their classes. I mean, I had this tremendous class in law school from a professor who later became a Court of Appeals judge, Douglas Ginsburg, on economic analysis of that I benefited from greatly. But a lot of students who probably need that kind of class won't be taking that class. So you need to come up with a way of integrating it across the curriculum. And I'd say that for other disciplines as well. If you're really interested in inculcating that body of knowledge, you have to figure out how to integrate it across the curriculum. And that involves hiring, not necessarily changing people's syllabus or what they're teaching. And I think that's why having a disciplinarily diverse faculty is a good thing and can really benefit students and in important respects, get economic issues and analysis out there. I do have a similar experience as Bobby with employers, except the employers I've been dealing with are always telling me that they need students who know more about accounting. There should be, more lawyers, accounting for lawyers classes, things like that. We need more hard business knowledge among law students, as opposed to that softy kind of knowledge they get in some of their classes, according to the employers.
Thank you, Kevin. So this is all the time that we have for this particular session. We have 2 minutes left, so I'm going to exercise my moderator privileges to say something to all the law students and economic students who are listening to this. We briefly touched on this. Does law have anything to teach to economists? I am one of them, but I think law has a lot to teach to economists and to the discipline. In fact, economics generally applies its general theory largely to abstract concepts of the property exchange, firms, technology, capital, even labor. But as David Friedman has said, quite a lot of what lawyers and law professors do involves dealing with the same concepts in their real world incarnation, which is very, very different. Some of you talked about critical race theory, but sociological, political, cultural dimensions of not just CRT, but religion, caste, cultural differences. There's so much complexity that is not taken up in the true form. But I'll end on with a story. It's a very interesting one. Some of you might know this. Around the 1960s, when this movement was picking up in the United States, Aaron Director, who's the founder of the Journal of Law in Economics, he had hosted a dinner at his home for Ronald Coase to discuss his theories on property rights, which they considered in error at least, and at worst, hearsay. They wanted to understand the arguments that he had presented in his 1960s famous paper. And the crowd was really top-notch people. It included Milton Friedman, George Stigler, Arnold Harburger, John McGee, really the enlightened minds of the time. The discussion began with 20 of 21 people opposing Coase and his arguments, and it quickly, and the whole thing was then called and described as Coase theorem, which we now know very popularly. And it led to a Nobel Prize for Coase, of course. By the end of the evening, by the time dinner was over, it was dessert time, all 21 of the attendees endorsed the paper and Coase's arguments. Coase had successfully converted all of them. In fact, according to John McGee, and I quote, the debaters stumbled out into the evening air in a state of shock, mumbling to each other that they had witnessed intellectual history. Now, since then, the famous 1960 paper by Coase, titled Problem of Social Cost, is still probably the most cited law review article of all time. So, law students, there is something.
Can I add, though, Ashish, just a quick tack on to highlight sort of the complexity of those, of course, is that Ronald Coase, to the end of his life, including I recall in a conversation I had with him, said, "It distresses me that my name is associated with a theorem that I never advanced." So unfortunately, those 21 people in the room took what he said and they made the Coase theorem, which wasn't actually what he had argued. Yeah. Exactly. So to Kevin's point about the way in which, again, kind of these things get distorted and the politics of it, Coase was never of the argument that, you don't need law. To the contrary, he was suggesting that law has this important consideration, but unfortunately in other hands, it became something different. But anyway, I love that story.
Absolutely. No, thank you for that comment. But that's all the time we have. Thank you so much, Shilpi, Bobby, Robert, Kevin, for your time and your wonderful insights that you've shared. I'm sure all the participants have benefited. Thank you very much.